Hi, welcome everybody. I see we've got people joining us. We're gonna just do a little housekeeping before we get started with our program today to give people a chance to get signed on. I'm Lisa from the Law Library, and with me today is our speaker, Nick Cohenmeyer, San Diego landlord-tenant attorney, who wants you to learn the law proactively and not as a defendant in a lawsuit. So I'm glad you're able to join us today for this presentation. Just a couple of things I wanted to mention before I turn things over to Nick. This is a CLE presentation today, meaning that attorneys can get continuing education credit. For this hour, what we will be doing is sending out an email with your CLE certificate a little later this afternoon, once I'm able to pull up a report and verify in Zoom who attended today. So you will be getting that by email. This is also an interactive presentation. You will have a chance to post some questions in the Q&A for Nick. Now, you'll see on your screen, if you're not a regular Zoom user, there's an icon that says Q&A with a couple of speech bubbles. That's where you want to click and post questions. You can do that anonymously or under your name, whatever your preference is. And we will try to get to as many of those at the end as possible. Nick has a lot of material today. And so we're going to try to do the best we can, but those will be taken at the end as time allows. There is also going to be a link to a survey that you will see as you leave the presentation today. If you can take a few minutes to take that, we would greatly appreciate it. And thank you in advance for that. And I think that's everything I had to say. So I'm going to go ahead and turn things over to Nick.
Hello, good afternoon, everybody. Today's presentation is different from the presentation I gave on June 23rd of this year. In that case, that was primarily geared towards tenants regarding this topic. So instead, the intended audience groups for today's presentation are California residential landlords, property managers, as well as real property attorneys advising the aforementioned. Now, since you came here presumably for the free MCLE and not to hear about me, I will tell you about my practice and provide my contact info at the end of this presentation. So let's get into it. So what is a co-tenant? Now, a co-tenant is defined as two or more tenants who rent the same property under the same lease or rental agreement, even though those leases or rental agreements may have been signed at different dates. Now, courts have affirmed the legality of shared housing arrangements in California and have been skeptical of local zoning ordinances limiting the rights of unrelated adults to share housing. Now, co-tenants are generally jointly and severally liable, as long as that language is in your lease or rental agreement, for paying the full amount of rent, as well as complying with the full terms of the contract they signed with the landlord. So what are some common reasons why tenants might want shared tenancies? Now, I'm going to skip over the obvious ones, but many tenants choose to live in shared housing situations for reasons such as marriage or romantic cohabitation. And also, especially in San Diego, it's just too expensive to be able to afford a premises on your own. So in light of a recent, albeit temporary, California law, there's also a new reason that has emerged for shared housing arrangements, and that is the alleviation of homelessness. Now, that is under California Civil Code section 1942.8, which I will discuss in a little bit. So why landlords might prefer to limit shared tenancies. Now, changes in occupancy, subleases, assignments, roommate conflicts can be a major source of confusion for a property owner. And in general, if a landlord can receive the same monthly rent with one tenant as the landlord can receive with, say, 4 tenants, the landlord will probably prefer the former, as wear and tear, costs, and complexities to the landlord will generally be lower with fewer roommates than with more. And lastly, when each co-tenant has a contractual relationship with the landlord, it will probably be very difficult for one co-tenant to evict a fellow co-tenant, which means it will probably be up to the landlord to get involved, usually through an eviction, unlawful detainer, against all the co-tenants. So you or your landlord clients, for those of you who are watching this as attorneys, will need to objectively weigh the burdens versus the benefits of allowing shared co-tenancies, unless, of course, there's a prohibition on prohibiting them. And that's why these presentations cannot be considered legal advice. Obviously, none of this is specific to any one person, any one client's individual matter. This is an overview where, as their advisor, as their counselor, you will recognize the overarching concepts and then be able to do your own legal research to drill in on the nuances and then apply those to your client's immediate facts. So screening co-tenants, the same general rules that apply to screening any applicant are applicable to screening co-tenants. So therefore, the property owner should require that each applicant 18 years of older completes an application to rent and should evaluate the applicants to determine whether they meet the owner's established screening criteria. Now, this isn't legal advice, but this is what I generally advise my landlord clients to do, is always have an application. That weeds out a vast majority of the applicants who are not serious applicants. And when you combine that with an application fee, you're eliminating an even larger threshold of applicants who are just, spraying and praying, sending out applications everywhere and hoping that maybe they get a bite, like almost like fishing. It's a waste of your client's time. It's a waste of their money, a waste of the property manager's time if you're not dealing with applicants who are serious. Now, as a side note, I did a presentation on California's reusable screening fees that recently became law, where a landlord can, not necessarily shall, it's optional, but a landlord can accept a reusable screening fee, which alleviates the applicant from having to pay separate $35 application fees per se for each application, which can certainly add up given the shortage of housing. So the presentation on that is a different presentation I did, and I'm not going to get into that because we have to stay focused on just the theme of this presentation. There's still so many nuances within just the theme that we're talking about today. So keep in mind that property owners must decide how they'll handle the resulting information, whether to combine the, for example, the qualifications such as monthly income of the applicants, or require each applicant to qualify independently. And we're talking about applications to rent still. So for example, if one co-tenant applicant has a dismal credit rating, but the other applicant has a stellar credit rating, then the property owner must consider whether the applicants together would meet the credit score criteria, or whether each person must have the minimum required credit rating. Now, I'm using property owner with property manager, landlord. These are all kind of interchangeable for the purposes of this presentation. I hope that's obvious. Now, be aware, if married couples are permitted to aggregate their income or combine their credit scores to meet the property owner's screening criteria, then the law requires that the property owner allows unrelated co-tenant applicants to do the same. All right, so that's an example of where California recognizes all of the federal protections and then takes federal protections even further for California law. And I'll talk about that more in a minute. Now, who should sign or be named in the lease agreement? Every person residing in the unit should be named in the rental or lease agreement as either a tenant or occupant. And I'll explain the distinction in a few slides. So it's recommended that anyone over the age of 18 be named as tenants and be required to sign the agreement. But individuals under the age of 18 should be listed as occupants, not tenants, on the rental lease agreement of the responsible adult. Now, minor household members should be added to the rental lease agreement as well as tenants if they have turned 18. So that's why a landlord should always have the names of minor children on the lease or rental agreement, because many times families start with minor children and they end up staying so long that those minor children are now adults. And it's always a good idea to know who is residing in your unit. And it's not just recommended, it's basically required for many different aspects of running a landlord business. And I refer to it as a business because there are many aspects of a business that pertain to competently running, especially in multifamily, especially when you have 16, 17, 30, 50 units, you have on-site managers, you're paying them W-2s. It's a business. And as a quick side note, a lot of landlords don't realize that if they're providing even just free housing to their property manager, they're not charging them for anything. That could subject you to disclosures for IRS. And I can't give tax advice, but look into that. Look in to see if your client is giving free housing and whether they need to provide workers' comp insurance, et cetera, all the other requirements that you would have if you're in an employer-employee relationship. Don't find out the hard way after your property manager gets injured chasing down a transient, and then it's discovered that the property manager did not have workers' comp insurance for him, that was a case. So look into the details. Now, roommate agreements. No roommates should go without an agreement among themselves. So at a minimum, a roommate agreement should include provisions that cover things like who pays the rent and how much, utility bills, gas, privacy, quiet hours, smoking, pets, personal possessions, where are you allowed to keep your possessions in the common space or only in your room, food. There's a lot of food theft, I remember from college, but security deposits, bedrooms, parties, etc. It's always, I think, a good idea to have these things thought of in advance and written down. And hopefully you'll have it and not need it versus needing it and not having it when tensions arise. And when you are living with people day after day, they have all kinds of mood swings. Chances are that problems are more likely than less likely to occur eventually. And you are doing yourself a favor if you're the landlord or if you're advising your landlord client to insist that the roommates work out a roommate agreement. Now, of course, a roommate agreement is not binding on the landlord, but it is binding on the tenants who sign it. It's not the landlord's responsibility to make or promulgate the roommate agreement, nor is it the landlord's responsibility to enforce roommate agreements, but encouraging tenants to make a roommate agreement can be to the landlord's benefit because roommate disagreements are not good business for the landlord. So landlords might want to consider keeping just a blank template and encouraging co-tenants to make one for themselves if they wish. And roommate agreements don't need to be formal. It's better to have at least something more than nothing to start with. And you can find a roommate agreement template online. And what I generally do when I have landlord clients that are requesting one is I have one that I continue to modify every time an unforeseen conflict that we didn't have anticipated in the agreement comes up, then I add it to the roommate agreement. So the clauses are growing, just like our lease agreements are always growing by the year. It's just anticipating things that were a first impression last time. There's no excuse to not codify that in a roommate agreement since you're already on notice that that kind of problem might occur again. So when co-tenant disagreements become the landlord's responsibility. Now, while landlords are normally under no duty to involve themselves in disagreements among tenants, if any dispute among roommates becomes serious enough to threaten the health and safety of tenants or disrupts the quiet enjoyment of other tenants, then the owner may need to step in to minimize potential liability. Now, owners should ensure that their tenants understand that it's not the owner's responsibility to mediate conflicts among roommates, and that the entire household could face eviction if the conduct of any household member or guest violates the lease or causes a nuisance. So does a landlord have to allow co-tenants? Well, local rent control ordinances and fair housing laws could prohibit a landlord from denying a request to add a new co-tenant or occupant or imposing financial burdens as a condition of approval. So for example, a policy that might prevent tenants from adding their minor child to the rental or lease agreement as an occupant, or which might require the tenant to pay an increased security deposit, will probably violate fair housing laws. Now, similarly, a disabled tenant may require a reasonable accommodation to have a live-in caregiver, or a tenant may need a reasonable accommodation to add a disabled family member to their household. So due to these various practical and legal considerations, rental property owners should develop a clear policy in conjunction with their attorney for handling requests to add a new co-tenant or occupant, and then should apply that policy consistently. Now, when at least one of the original tenants vacates and is replaced by one or more new tenants, it's generally in the best interest of the landlord to have all the new tenants sign a new month-to-month agreement. And just a new rental agreement, right? It could be annual, could be any term. So new rental agreement. And if the tenancy is based on a fixed term lease and the occupancy changes partially through the lease term, well, that's a little more complicated, but generally the landlord and the tenant can voluntarily elect to add an addendum to modify the terms of the lease, so long as it's mutual, so long as it's not one-sided, initiated by the landlord or just the tenants. So in that case, the option could be to execute a change in occupancy addendum, which clearly specifies which tenants are remaining, which tenants are vacating, and requires any incoming tenants to acknowledge receipt of the existing rental lease agreement and be bound by its terms. And if you're thinking, what about security deposits? I'll cover that in a minute. So drawbacks of using separate agreements for co-tenants. Now, the inability of landlords to institute partial evictions in most cases has been cited as a reason to just execute separate rental agreements for each tenant. So why would that be a bad idea? Well, here's one of the possible downsides to that approach. And again, we're talking about separate agreements for individual co-tenants, right? So one of the problems is that by executing separate rental agreements, each tenant's independent obligation to be fully responsible for the rent of the others would practically be eliminated. You need one agreement signed by all the co-tenants with the language of holding all of them jointly and severally liable, which means the landlord doesn't need to care who's paying what. The landlord only cares that it was paid in full and paid on time. So, but of lesser importance is the hassle for the landlord to manage multiple leases or rental agreements for individual tenants. This could require keeping track of multiple expiration dates and ensuring that whenever an update is made to one agreement, then the same update is made to all. I mean, imagine how confusing that would have been during 2020, 2021 with AB 38 and all the new legislation starting with AB 1482. So that's why you could do separate agreements, but there are downsides, and I wanted to make sure you're fully considering not just the benefits, but as well the drawbacks. So here's some issues with rental payments when it comes to co-tenants. Now, co-tenants normally have to decide among themselves what portion of the rent each co-tenant will contribute. And regardless of any such agreement between the co-tenants, your landlord-client's rental or lease agreement should normally make each individual who signs the rental or lease agreement liable not only for their share, but for the entire rent should any other co-tenants default. So therefore, if one tenant cannot pay his or her share of the rent in a particular month or simply moves out, the other tenants must still pay the full rent. Now, this will probably be a headache for the co-tenants, but it should not be your landlord-client's headache. The paying co-tenants may in turn pursue recovery from the defaulting tenant in their own civil lawsuit against the co-tenant in arrears to them, but your client could potentially be called by either party as a witness, however, should refuse to participate as a plaintiff unless your client has also suffered damages directly. Now, another tool for your landlord clients is to insist in their rental lease agreements that rent be paid with one check for the entire rent amount rather than individual checks from individual co-tenants. Now, this could create headaches for the co-tenants, but it will not be your landlord clients' headaches. As I've mentioned before, owning and especially managing residential real estate will already present your landlord client with plenty of headaches of their own. So to summarize, make sure that you're reviewing your landlord client's rental lease agreement to ensure that the paragraph pertaining to rent payments especially unequivocally mandates that each month's rent shall be paid in a single payment. And if that language is not in their currently executed agreement, then provide your clients with an updated agreement at the soonest possible eligible juncture, and make sure there also is language for joint and several liability. So now we're talking about security deposits when it comes to co-tenants, because this is one of the most common disputes between, well, landlords and their tenants, just security deposits in general. Now, if you want a refresher on the intricacies of California's security deposit rules with suggestions of how to best position and protect your landlord clients to avoid many of the foreseeable headaches, I did another MCLE presentation on this topic. That was back on April 4th of this year. And that was also through the San Diego Law Library. Now, California law is clear on the amount of money a rental property owner can collect from a tenant, and it provides a specific time frame within which the owner must return the deposit and or provide an accounting after possession of the unit has been returned to the owner. And I think we all know what that deadline is. Everybody who doesn't, it's 21 days, but don't wait until 21 days. So this is where we're talking about when to return it. So the purpose of a security deposit is to ensure that the unit is restored to its pre-move-in condition, obviously exclusive of normal wear and tear. So therefore, it would defeat the purpose if the deposit or any portion of it were returned by the owner to an individual tenant before the unit is returned to your landlord client's possession. So as you know, California requires an owner or property manager to return the deposit no later than 21 days after the unit is returned to the owner's possession. And it does not mandate that any return of a security deposit be returned to any individual roommate. But when I'm advising your clients, you might want to consider to cut this deadline to 2 weeks instead of 3 weeks, just to leave a cushion for corrections or other problems that happen with mail that could turn $1,000 security deposit refund into a $3,000 judgment should the statutory penalty of treble damages attach due to your client's unjustified delays in the return of the security deposit. The security deposit is not income. You're just holding it for someone. And it's very hard for some landlords to give up that money, which they wrongfully attribute to their possession. It's not. It's very strict on when it shall be returned, what it can be withheld for, what requirements are obligated to be adhered to if you are withholding the security deposit for certain deductions. And again, look at the other presentation I did on that because I can't go into the detail on security deposits to that level on this presentation. Now, unless the lease or rental agreement provides otherwise, the security deposit is not divisible and stays with the unit. So the deposit should not be returned until after the unit has been vacated, because the owner will need the opportunity to assess and make the appropriate deductions for damages to the premises. Now, the reason the security deposit disposition is normally not done until the unit is completely vacated is because the owner doesn't have the right to inspect the unit when a co-tenant vacates, but the unit still remains occupied by other co-tenants. So more issues with the security deposit, what to request in advance. I can't give legal advice, but one might consider using a security deposit disposition agreement that would be negotiated between the owner or property manager and outgoing tenant in advance of the outgoing tenant's departure. Now, this benefits both sides because it makes the outgoing tenant's preferences clear as to the manner and location to send the security deposit remainder, while also streamlining the process and thereby benefiting the property owner who will be sending the check by helping the owner avoid running afoul of the 21-day statutory deadline. There's never going to be a better chance to get a hold of your outgoing tenant than when the outgoing tenant is still at the premises and you are able to speak to them and get their information now. It becomes exceedingly difficult in some cases to track down an outgoing tenant after they're gone, when they might be staying at a friend's, at their parents', at a hotel, living in a Sprinter van. There are numerous headaches that are foreseeable if you don't do a security deposit disposition in advance. And lastly, with security deposits, who is entitled to the security deposit disposition? Well, unless the tenants have agreed otherwise in writing, for example, if a replacement roommate bought out a former roommate's portion of the security deposit, then the owner should issue the security deposit refund payable to all of the tenants, even if one or more of the tenants vacated at an earlier time. So as a practical matter, this means co-tenants must work out among themselves what to do when one tenant leaves. And if unrelated co-tenants are entering into a lease or rental agreement together, the landlord may want to make this clear at the outset of the tenancy so it doesn't come as a surprise when one tenant plans to vacate. So who's not entitled to the security deposit disposition? Well, California law requires that the security deposit itemization and refund be returned to the tenant. So therefore, the owner should not name non-tenants in the security deposit itemization and or refund check. And as I discussed a moment ago, occasionally persons who occupy the unit will not be tenants, such as long-term guests or caregivers. Now, these non-tenant occupants should not be named in the security deposit itemization and or refund check. And furthermore, 5 years ago, in 2018, California codified the right of tenants to have their rent paid through third parties, provided certain rights and requirements are respected. Now, I'll discuss this more on the next slide. So with third-party payments, effective August 28, 2018, AB 2219 amended Civil Code Section 1947.3 to require residential landlords to accept rent payments through a third party if the payor provides a signed acknowledgement stating that the payor is not currently a tenant of the premises and that acceptance of the rent payment does not create a new tenancy with that third party payor. Now, within Civil Code Section 1947.3, subsection C, you can find the following sample form acknowledgement, which I put on the screen here. And that says, if you can't read it, I name a third party, state as follows. I'm not currently a tenant of the premises located at address of the premises. I acknowledge that acceptance of the rent payment I'm offering for the premises does not create a new tenancy. So if a landlord has been accepting rent payments from a person who is not on the rental lease agreement, or has allowed an additional occupant who is not on the rental lease agreement to reside in the unit without having a written agreement which clarifies the person's status as a non-tenant, one might wish to amend their client's rental lease agreement and definitely have a conversation with them about this potential exposure. So make sure, which is not legal advice specific to your case, one might say that a client's rental lease agreement should provide that rent payments will not be accepted from third parties absent a written agreement, and that's within compliance with the law. So potential strategies for co-tenants to recover security deposits. And this is the last slide on the topic of co-tenants. The following solutions are commonly used between co-tenants to resolve the type of situation I just described. So for example, an incoming replacement tenant may pay the departing tenant his or her share of the deposit. And this is advisable only if the unit has been maintained prior to the new tenant taking possession, since any preceding damages would be imputed to the new tenant and or the other remaining tenants. 2, if there will be no replacement tenant, then the remaining tenants can essentially buy out the departing tenant's interest in the security deposit. 3, the departing tenant may wait until his or her co-tenants have vacated and then seek reimbursement at the time. Now, this might create problems, however, in the situations such as where damage occurred to the unit after the first tenant vacated. And then 4, if the tenants cannot agree to resolve the dispute among themselves, then the tenant seeking to recover his or her share of the deposit may bring an action in small claims against the co-tenants to recover their share of the deposit. So let me take a quick sip, and then we're going to talk about overnight guests. So how many days is a reasonable maximum for overnight guests? So if you're looking for help in deciding how many days to limit overnight guests in your lease rental agreement, well, you can consider that for mobile homes. California limits guests for up to 20 days consecutively or up to 30 days in a calendar year without permission from the park owner. And then anything beyond that would require an agreement. So a residential landlord in California is mostly free to restrict guests in terms of the number of days, so long as the landlord doesn't restrict the type of guest. Now, while it should be obvious, but in case it's not, a landlord can never restrict guests based on any state or federally protected category. And keep in mind that California generally offers broader protections than federal law. So, for example, California law even provides protections for unmarried couples. And if a guest ever claims that he or she is a tenant organizer, anything like that, or is there to provide tenants with information about their rights under California law, then a landlord absolutely must not restrict these types of guests. This would be similar to union organizers in commercial context. Now, both union organizers, tenant organizers have rights and protections to be there, and a landlord could face serious penalties for interfering with their right to help others understand their rights. One of the exceptions might be, however, if that tenant organizer is inciting a disturbance or otherwise interfering with the other guest's right to quiet enjoyment on the property. Now, where that is the case, the landlord could and likely should correct that disturbing behavior, and it would be wise to do more than just write down the description, have some photo, video. Many clients now have surveillance. Make sure you save that footage in case you have to have some kind of affirmative defense later if your landlord is named in a lawsuit for ousting a tenant organizer. Now, long-term guests, preventing guests from becoming subtenants or occupants. Now, one of the reasons why standards for guests should be unequivocally spelled out in the lease or rental agreement is that rules that are not written are not only generally more difficult to enforce when it comes to landlord-tenant law, but in some contexts could not even be enforceable. So in addition to having clear rules in place, the landlord should also have systems in place to monitor and track the length of stay by overnight guests in the landlord's properties. And if the landlord doesn't enforce these rules and overstay limits, then the guests could eventually begin to adopt rights that will make removal even more difficult and may necessitate the removal of the original tenants as well. So how can you handle overstays? Well, when your landlord client becomes aware that an overnight guest is about to or has already stayed longer than the contractual maximum number of days under the lease or rental agreement, then your client may wish to treat the overstaying guest essentially as an applicant to rent and then provide the overstaying guest with an application to rent. It's not mandatory they do so, but that's one avenue. Now, treating the guest as an applicant means providing the same written disclosures that are normally required. For instance, like if you do a credit check and if you find adverse information, then if your landlord decides not to offer the tenancy based on that adverse information, the landlord would still need to provide the additional forms, such as a notice of denial to rent. And if the overstaying guest, now turned rental applicant, does not meet the same objective standards that any other applicant would be expected to meet, then the landlord's next option might be to serve the original tenant with a 3-day notice to perform covenants or quit, which would force the tenant to remove the overstaying guest within 3 days due to an express violation of the contractually agreed upon maximum number of days per guest. And if you don't have familiarity with doing a 3-day notice to perform covenants or quit, well, your attorney does. And if you're the attorney and you're not familiar with it, then make sure, again, not specifically legal advice, one might recommend that you specifically cite the provision in the mutually executed lease agreement in which that tenant agreed to abide by the overstay limits. That's why you need to have overstay limits. You need to have specific two figures you need. You need one figure that shows the maximum number of consecutive days that they can stay, and a second figure that shows the maximum total number of days per year that guests are allowed to stay. And you cite that paragraph, among other things, in that 3-day note. So you're being abundantly clear that you're not acting arbitrary. You're treating this tenant as you would any other tenant who breaches the covenant. So is the landlord obligated to offer a tenancy to a guest? It seems like this could be a backdoor way to get an unqualified guest into a tenancy. Well, the landlord is not obligated, but there are certain caveats. So one common reason landlords might have for not offering a tenancy is that additional occupants in a unit will probably increase wear and tear and the consumption of water and electricity and gas, but which should really only be an issue if these are not sub-metered and the landlord's paying for them. But another reason might be that some landlords won't or can't increase the rent when additional guests are moved in. So the landlord would essentially be having to bear the increased expenses without increased revenue to compensate. And I'll explain in a moment why the enactment of AB 1482 has complicated this decision for landlords. So when might a landlord be obligated to offer a tenancy to an overstaying guest? Well, the first consideration for a landlord in making this determination should be what type of guest. If the overstaying guest is, say, an immediate family member or caretaker, then in most cases, the landlord probably does need to offer them a tenancy. But any other type of guest is probably not entitled to the offer of a tenancy. Just remember that before a landlord makes that determination, or if you're a tenant who thinks the landlord made an improper denial for you, then it would be wise to consult with an attorney with competence in this area to ensure that any local ordinances don't change this presumption. Now, because of the added wear and tear and consumption of additional utilities that will probably be caused by additional occupants, it seems reasonable that a landlord should be entitled to offset the landlord's cost by charging a guest fee to the tenant. However, here are some of the potential problems to consider before a landlord charges these fees. First, a landlord who charges guest fees, especially for guests that stay beyond the contractual maximum, might be considered to have waived the right to enforce the contractual maximum by accepting these fees, and thus the guest. And this could potentially even change the guest status from guest to tenant. And this could make an eviction even more difficult, since the landlord now would be on notice that there are additional occupants in the premises and would need to identify them as John Does or by name specifically, or do a prejudgment, claim to right of possession. I'll talk about that in a sec. Charging a guest fee might be found to be part of a rolling 12-month gross rental rate that the landlord has been charging monthly for the tenancy. And the significance of this is that for properties that are subject to AB 1482, which took effect in 2020, there are restrictions on how much, how often a landlord can increase the rent over a rolling 12-month period. And typically, as you probably know, the rent cap is normally 5% plus a change in CPI, never to exceed 10%, but some local ordinances restrict this amount downward further. So if you're going to charge guest fees, and I'm not suggesting that you should or can, make sure the amount you charge can be reasonably substantiated based on actual costs for increased utility consumption and depreciation, not due to your own arbitrary and subjective estimations. At the time of this presentation, neither statutory nor common law is on when and how much a landlord can charge for a guest fee. But one strategy I've seen landlords use is to calculate the change in average baseline usage from months prior to the guest presence to after. So in summary, unless the tenancy is a mobile home tenancy, which today's presentation is not going to cover, but I did do a presentation on that, which I can provide if someone wants to ask. I did that through the SDVLP, San Diego Volunteer Lawyer Program. Now, again, unless the tenancy is a mobile home tenancy, there is no predefined minimum number of days that a landlord is obligated to allow overnight guests in a tenancy. And again, mobile homes are governed by usually the MRL, the mobile home residency law. And if you want the presentation on that, find a way to contact me, and I'll have my contact information at the end of this presentation. So this is why I strongly urge landlords to clearly specify limits on how many days an overnight guest may reside in a rental unit, and to have some kind of system in place to proactively monitor the frequency of overnight guests and to enforce any known breaches of these limits. So some differences between occupants and guests. Now, it should be relatively clear what constitutes a tenant, because a tenant will normally be a signatory to a lease. But what gets more muddled is who's an occupant and who's a guest. So if a non-tenant occupant is only temporarily occupying the unit, then he or she is presumably a guest, and it wouldn't be appropriate to name the guest in the rental or lease agreement. So who would be an occupant? Well, one common category of occupants would be minor children living with a tenant. Now, occupants under the age 18, minors, do not normally need to be named in the lease agreement. So the main significance of the guest occupant distinction is that occupants are typically named in the rental lease agreement, but do not sign the lease. And contrast both occupants and guests to tenants. Tenants should almost always be named in and be a signatory to the lease. And it may be a good idea to name minor children as occupants, even though you don't need to name them. They certainly don't need to sign anything, because I can't, but it might be a good idea for both sides to have an idea of what the names of the children are in case there's an emergency, as well as children tend to turn into adults if you give them enough time. And if the people stay for 18 years or more, you're going to have adult children residing there if the kids stay there, as for obvious reasons, many children are doing. And I don't think there's anything wrong with that. It's difficult to find housing, difficult to find enough employment that can compensate for the cost of living in San Diego where we live. So I'm not saying I live with my parents. Occupants with disabilities. So another subcategory of occupant is when a person over the age of 18 is permanently occupying the unit to care for the tenant. So similarly, you could have a lawful occupant where a disabled adult occupant lives with and is being cared for by a tenant. Now, landlords need to be careful when denying occupancy to disabled individuals or their caretakers, as such requests could be considered reasonable accommodation requests. And there's a reason why I say that specifically, because these are kind of trigger words that require a specific follow-up. If they're asking for a reasonable accommodation, then the landlord can find themselves in legal trouble if they deny the reasonable accommodation request without going through another buzzword, interactive process with the individual requesting the reasonable accommodation. Now, what I've seen some landlords do is that that's not a reasonable request. That's not a reasonable accommodation request. I don't need to go through the interactive process. You probably do, even if it's completely ridiculous, you probably do, as due process as well as due diligence, because you could face a lot more problems if you don't go through it and a court finds that the accommodation that your landlord did an on-the-spot adjudication and deemed it not reasonable might actually have been a reasonable accommodation, and now your landlord's in trouble for not going through the interactive process, even if they know the interactive process is still going to lead to a denial. Not a good idea to just make that decision at the landlord's level. So what to do when a person moves into the rental unit without applying or being approved for a tenancy or signing a rental lease agreement? Well, depending on how often and for how long this is occurring, you probably have an unauthorized occupant issue. Now, this situation commonly arises in two ways. One, where a current tenant allows another person to move into the rental unit without the owner's permission, or two, where the tenant on the rental lease agreement has vacated the unit and the unauthorized occupant occupies the unit. So if a current tenant allows someone to move into the rental unit in violation of a lease provision prohibiting subletting, then the tenant has violated the lease. Now, if this unauthorized occupant was added per an unlawful sublease or assignment, then California law technically allows a landlord to immediately serve a 3-day notice to quit with no opportunity to cure to a tenant who has violated a lease provision against subleasing or assignment. But if it's the tenant's first violation, it's usually a better practice to give the tenant a chance to fix the problem. So consider doing a 3-day notice to cure or quit instead of just a notice to quit. Now, in most situations, the landlord can serve the tenant with a 3-day notice to perform covenants or quit, requiring the tenant to either remove the unauthorized occupant and not allow any additional persons to move into the unit without first applying and being approved and signing the rental lease agreement, or move out and return possession of the unit back to the owner. However, landlords subject to a local rent control and or just cause eviction ordinance should get some legal advice, as the local ordinance may limit the landlord's ability to require the unauthorized occupant's removal. Now, occasionally the tenant on the rental or lease agreement will have permanently vacated the rental unit, leaving an unauthorized occupant living in the unit. For example, this situation sometimes arises when an elderly tenant passes away and the tenant's caregiver refuses to vacate the unit. Now, depending on the facts of the situation, it might be possible to treat the unauthorized occupant as an unlawful occupant or tenant at sufferance, and to evict the unauthorized occupant through either an unlawful detainer or forcible entry and detainer action. But in order to do this, you'll likely need to serve a pre-judgment claim of right to possession, which I will discuss on the next slide. If the landlord has agreed to allow the occupant to stay in the unit or has accepted rent payments from the occupant, however, then the landlord may have created an implied month-to-month tenancy. So why serve a pre-judgment claim of right to possession? Well, I can't really think of really good reasons not to. I could see reasons not to because they're inconvenient or because it requires you to use marshal or process server, professional process server or sheriff, but it's really not a bad idea to do it, even if you don't think there's any, unauthorized occupants living there. So anytime, I'm filing an unlawful detainer and my clients suspect that there may be unknown occupants residing at the property, then definitely I'm filing one. And even if we don't know whether there are, I'm still usually filing one. It's a form CP 10.5. And this is officially known as a pre-judgment claim of right to possession. And I'm going to abbreviate it as PCRP because I'm going to refer to it a few times in this slide. So what is the purpose behind the PCRP, the pre-judgment claim of right to possession? Well, first, it's governed by California Code of Civil Procedure, section 415.46, and I have that on the slide. And a PCRP is used to avoid third-party claims and unlawful detainer action by notifying any occupants residing at the premises, but not known or named in the primary unlawful detainer action, that a UD has been filed. And if the unnamed occupants do not add themselves by name to the UD action, then they could be evicted without a further hearing. So why would a landlord want to make it easier for an unknown occupant to delay a UD action? Well, the reason is that without exercising the good faith and due diligence that a PCRP mandates, then a landlord could be even worse off, since an unknown occupant would have the right to file their own PCRP, which can postpone the eviction, and will normally be notified by the sheriff at the time of the service that they can file their own PCRP within 10 days of being served the summons and complaint. But moreover, if there ends up being an unknown occupant and the PCRP was not filed, then the sheriffs will usually only lock out the named parties and not the unnamed parties. So a separate eviction could possibly be required for those new parties that were previously unnamed. And as you probably know, each eviction is going to take several months. And that's usually in a best case. It's not a good idea to assume that there's nobody there without doing your due diligence. So consider the PCRPs and subleases. So whether a roommate should be considered a co-tenant or subtenant depends on whether A, the roommate has a contractual arrangement with the landlord directly. And if so, this would likely be a co-tenancy. Or B, the roommates have an arrangement with one tenant, i.e. the master tenant, who has a contractual relationship with the landlord. Now, in this case, this would usually be a subtenancy. And a subtenancy is what I'll be discussing in this section of the presentation. And now you can probably see why I do these individually, where I'm not giving a group presentation, because I have so much information to cram in 1 hour that during normal presentations with an audience, you get sidetracked. So I hope you find this presentation format helpful. Please leave comments at the end, and also let me know if you find these graphics helpful or distracting. All right, back to the main slide here. So what is a subtenancy and who is a subtenant? A sublease or subtenancy is an agreement in which a tenant rents out all or part of the tenant's leased premises to a subtenant. Now, the original tenant could also be referred to interchangeably as a master tenant, or the sublessor, and the new tenant that rents from the master tenant could also be referred to as a subtenant, but usually in some cases referred to as sublessee. I'm usually going to refer to them as a subtenant, but again, interchangeable: subtenant, sublessee, master tenant, sublessor. The master tenant normally does not relinquish control over the leased premises and usually plans to retake possession at a later date. That's one of the reasons how a subtenancy would differ from an assignment. So in the absence of a prohibition against subleasing an assignment in the rental lease agreement, subletting or signing the right of possession by a tenant is allowed in California. So both landlords and tenants should recognize that some local rent control and or just cause eviction ordinances prohibit an owner's ability to prohibit subleasing in certain situations. And lastly, it's important for master tenants to understand that by acting as a landlord, they probably will be expected to adhere to almost all of the same landlord-tenant laws that apply to landlords. So make sure, not that it's your responsibility per se, but your sublessor better understand what their obligations are when it comes to increasing the rent, when it comes to maintaining the premises in a habitable, satisfactory condition. There are a lot of requirements that sublessors are not ready to accept because they don't even know what they don't know. Now, subtenants could be roommates, but subtenants are not co-tenants. Now, why would subtenants not be co-tenants? Well, because a co-tenancy exists when two or more tenants rent the same property under a direct contract with a landlord, but under a subtenancy generally exists after the original contract was signed between the master tenant and the landlord. And because the subtenancy is usually signed later, then the master tenant and the subtenant would not be co-tenants. Now, why would landlords refuse to allow subleases in some cases? So quite often it's not in the owner's interest to allow subleasing because it takes control away from the owner in terms of deciding who may and may not reside in the rental unit. Also limits who the owner can hold liable for the rent and damages. Now, subtenants have no contractual relationship to the owner because subtenants have not signed a contract with the landlord. Now, this means that the owner can only go after the master tenant and not the subtenants for unpaid rent. But if the subtenant expressly assumes the master tenant's obligations under the lease and the landlord accepts the sublease, then both the landlord and the subtenant can enforce lease covenants against each other. And you'll see some of the cases I cited here. So if you want more information about that little, wrinkle of the law, look up Marchese versus Standard Realty, as well as Cordonier versus Central Shopping Plaza. Now, if, as I was talking about, both the landlord and the subtenant can enforce the lease covenants against each other, presuming that the landlord accepts the sublease and the subtenant expressly assumes the master tenant's obligations, then the landlord would be treated as a third-party beneficiary of the agreement, and the subtenant would be treated as a third-party beneficiary of the lease agreement. So the next slide is when the master tenant wants her subtenant out. We're really running short on time. I have to skip a few provisions of things I wanted to say here. But whether subtenants are considered lodgers or subtenants used to be a more significant distinction than it now is. And that's because under common law, if you could characterize someone as a lodger, that meant the master tenant can usually utilize self-help to terminate the interests of the lodger without having to engage the unlawful detainer process. And since lodgers may be considered roommates, who in turn may be considered persons who hire dwelling units under California Civil Code Section 1940, lodgers probably can no longer legally be removed via self-help under Civil Code Section 1940. So an alternative to subleasing that's still beneficial to the landlord is having a policy of allowing co-tenants, but not subleasing. And this gives the owner the ability to screen all potential tenants and hold all tenants liable for the rent while still allowing prospective tenants to combine their resources to rent an apartment or house. Now, in this case, each tenant may sign a lease or rental agreement with the landlord directly, individually, which we talked about earlier, has its own inherent problems, or just when the 30 days is up for a rental, month-to-month rental, or when the lease term is over, then sign a new agreement. Now, as you can probably deduce by now in this presentation, there are burdens to the landlord inherent with all types of shared living arrangements, but there are often disproportionately more burdens to benefits to the landlord when it comes to subleasing. And then 3 years ago, California essentially created a new type of subtenancy. Some might call it short-term rental, but it's more akin to a subtenancy to help mitigate our state's homelessness crisis. And that's what I told you I would talk about. And that's California Civil Code Section 1942.8. And this is supposed to be temporary. I mean, it took effect on January 1st of 2020, and it's scheduled to expire on January 1st, 2024, but you never know, it could be extended. So this is why it's worth learning about. According to the legislation's text, California Civil Code Section 1942.8 was intended by the California legislature to assist those at risk of homelessness and to encourage landlords and tenants to permit those persons to temporarily reside on their property. So under CC Section 1942.8, owners or landlords may, not must, but may, at their own discretion, agree to temporarily allow an existing tenant to share the occupancy of their rented dwelling unit by a person who is at risk of homelessness. So the owner or landlord is entitled to increase the monthly rent during the term for which the person at risk of homelessness is occupying the tenant's dwelling unit. But here's a problem that I have not found a sufficient answer for. If your landlord client is already charging the maximum statutory amount under AB 1482, which we talked about earlier in a different context, and again, could be even lower depending on the local ordinance, then how is your landlord client supposed to adjust the rent upward to offset the added costs of the occupant? So because the purpose of this presentation is not on Civil Code Section 1942.8 in depth, I urge you to read that code in its entirety so you'll see what rights and requirements your landlord client is expected to understand. So assignments, we touched on those earlier, and basically an assignment is an agreement in which the original tenant agrees to transfer all of his or her interest in the lease to another person, in which case the old tenant would now be the assignor, the new tenant is the assignee, and the assignee to whom the lease is transferred to steps into the shoes of the original tenant, the assignor, and becomes the new tenant of the premises with a direct landlord-tenant relationship to the owner. So landlords should think carefully before allowing assignments in their leases or rental agreements. And the way they allow it is generally by not prohibiting it, because by not prohibiting assignments, they may be granting an implied waiver. So similar to allowing subleasing, assignments can take away some or all of the landlord's capability to screen assignees and ensure that any assignees otherwise satisfy the landlord's uniform criteria for all tenants. Now, wrapping up, and this is essentially the last slide. The next one is just my contact info, so we made it. How is an assignee different from a subtenant? Well, in a sublease, the master tenant has not transferred their rights fully or permanently to the subtenant because the master tenant normally intends to return either to reoccupy the premises or to sublet to a new subtenant at the end of the subtenancy. Now, in contrast, during an assignment, the assignor normally does not intend to reoccupy the premises and transfers the assignor's rights completely and permanently to the assignee. Okay, we did it. We finished the presentation on time. I'm gonna have about 5 minutes or so for Q&A because I need to run next door to court, but I hope you found this helpful. I hope you found that I put some time into this. So I certainly am not asking anything of anyone, but if you did find it helpful, please let the law library know. And if you'd like me to do another presentation on another topic, maybe provide some suggestions. A little bit about me. I have been practicing California landlord-tenant law since 2011. I'm also a volunteer with the San Diego Volunteer Lawyer Program. I have over 1,000 pro bono hours with them. And that's how I've been able to learn landlord-tenant law. It's been very rewarding for me. I help both landlords and tenants, but most, not all, but most of my clients are landlords. I'm also a U.S. Navy reservist, and I am applying for a JAG commission. So if you or you know anybody who is an active or reserve JAG in any branch, especially Navy, would you please put them in touch with me or give me their info? I would love to ask them a few questions. I'm always looking to meet more local attorneys, especially. My contact info is here if you'd like to meet for a coffee. I live in North County, but I'm downtown all the time. And if you want to go for a dog walk, I have 2 poodles. So my contact information is on the screen. You should be able to scan it with your QR code. My website's nickcohenmeyer.com. And that concludes the substantive portion of today's presentation. I appreciate your time. So let's see if we have some questions here. And if Lisa, if you're available, you can chime in here. So,
Yeah, did you want me to read the questions, Nick?
yeah, I don't see them on my screen.
Oh,
so-
okay. Okay, well, here's one that maybe I can address after the presentation. I understand from Susanna, the handout link in the email I sent out didn't work. Okay, well, you know, I have a workaround for that. I'm going to be sending out the CLE certificates to everybody who's here. I will attach a PDF of the handout as well, along with the CLE certificate. So thanks for letting us know about that. So here's a question from Sergey. He's asking, does the California tenants law work equally on tribal lands? And then how is the price cap regulated on the municipal level, county level? Is there a price cap on the lease agreements? So do you know, Nick?
So well, okay, here I see the Q&A popping up now.
Okay.
So yeah, tribal lands is a whole different issue, and it's confusing because they're basically like sovereign lands, but there is some overlap where federal does have jurisdiction. State, that gets more complicated, but I'm going to not give a definitive yes or no whether, and when he says price caps, I assume he's talking about things like AB 1482 and statutory price caps. So I'm not going to address that for federal lands. I'm not qualified and competent to answer in that context. I don't practice tribal law. The other question he had was about the municipal price caps. Is there some kind of price cap on the lease agreements at the regulatory level? I think what he's, and tell me if you think I have a wrong understanding of his question, but what I think he's asking is, how is it regulated? He says on the country municipalities level. I'm not sure if he's still talking about tribal, but
Well, I think he means county there. That might be a typo.
Okay.
Yeah.
So at the municipality level, there is a rent calculator that if you're a landlord, California Apartment Association has a rent calculator that breaks it down by county or city, where the city has its own variance, and it's based on the consumer price index, and it's further nuanced by when the rent increase takes effect, because it's based on CPI figures that are published earlier in the year. So don't just go by any random CPI figure. Make sure it's through, for example, the California Apartment Association. That's the one that I tend to use. I'm not recommending it. It's just the one that I use because I found that it's trustworthy. And keep in mind that you have to look at the local level too. He said municipality, look at the local level. There could be a further ordinance that restricts the statutory 5% plus CPI never to exceed 10% down to a lower level. Okay. All right. Now I can see the questions. So, so is there recourse for damages if a security deposit was not included in a lease or charged, but damages by tenants were referred to in the lease? So, Lisa, can you explain what Kathleen is asking?
I'm not sure, Nick. I don't know. When I first looked at the question, I thought she was talking about a case where a security deposit wasn't provided by the tenant or asked for, but then damages occur.
I mean, the way that I could put this question together in a way that I think might make sense or be helpful to other people is that if the security deposit was not mentioned in the lease, but she's saying not charged, well, then that would kind of obviate the question. But if it's not mentioned in the lease, there still should be some kind of separate writing, some kind of separate agreement that shows what was paid, what was kept. And it's neither the landlord's exclusive responsibility nor the tenant's exclusive responsibility to maintain this, because the landlord, if you just go by what the landlord says, it might be wildly different from what the tenant agrees to. That's why both sides need to keep copies of their mutually executed agreements. And if there's any disagreement as to what amount of security deposit was in fact charged and received, do not proceed with the tenancy until that's resolved. Don't take the word for it either by the landlord that we'll get around to this later, don't worry about it, or don't take the word from the tenant who hasn't paid the security deposit that, oh, I'll get this to you in a week, just don't worry about it. Do a hard stop and get that addressed before proceeding. So let's see, we do one more. Thank you, Mary, for the compliment. Very nice. So if a guest happens to stay living with a tenant for more than 30 days, does the guest now have tenancy rights? Can a landlord force the tenant to remove the guest with a 3-day notice. How is this related to an eviction for a tenancy at will? So this is from, well, there's a lot going on here, but if a guest happens to stay living with a tenant for more than 30 days, that depends on what is explained in the lease agreement or rental agreement in terms of overnight guests and the cap on the number of days, either successive or cumulative for the lease per year. That's why there should be at least 2 figures, at least 1 figure, but ideally 2 figures, those 2 numbers I talked about. And if, let's say it's a 20-day cap and the guest is staying 30 days and the landlord continues to accept the normal rent from the tenant as the tenant had been paying for previous months, then the guest could be acquiring tenancy rights and the landlord could basically be giving an implied waiver by continuing to accept the rent without protest. Okay, so it is past 1 o'clock now. So I hope people found this helpful. Thank you for the questions. Thank you for the compliments. Really appreciate it. And let Lisa know if there's another topic that would be helpful to discuss.
Yes, and you can do that if you want to just reply to me when I send out the CLE certificates later and the handouts. And then just, I wanted to make one more little pitch to take our survey. And then also, I know Nick referred to a lot of different kind of template letters and forms in this presentation. If you need help finding forms or sample letters, feel free to contact the law library. That's something we can help you with. Thanks, everybody.